The Supreme Court has just stepped in directly to a massive constitutional clash that could completely upend how the criminal justice system operates in some states. If you think that your right to a fair trial is completely safe under the Bill of Rights, you need to watch out because the Supreme Court just granted review on a case that exposes how the government has actually been shortchanging your fundamental constitutional protections for over 50 years. This summer, the Supreme Court agreed to take up a fast-moving challenge known as Keon versus the state of Florida. On paper, this case started as a local dispute involving a state licensing case, but now it has become a question of what the founders of our country actually meant by your right to a jury trial. Currently, 6 different states have been actively bypassing the traditional 12-person jury requirement, convicting individuals using a shrunken 6-person jury instead of the 12. The current conservative majority of the Supreme Court just signaled that they are ready to completely tear down that loophole. And now we have a major procedural update. The clock is officially ticking. The opening merit briefs have just been filed in this case, and both parties are actively targeting live oral arguments in this case before the end of this year. So before the end of this year, the constitutional clash on this issue will take place. So we need to break down what is happening in this case and what was just argued in the opening briefs in this issue. Now, before we jump into what is going on in this critical Supreme Court case, if you like this type of content and you want to ensure that you get these videos going forward, make sure to subscribe and turn on all notifications to never miss these videos when I release them. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, and if you are a concealed carry holder and you're concerned about if you ever have to use your firearm and needing legal protection after the fact, I highly recommend you check out Attorneys on Retainer. I will leave links to them down below. They're one of the only companies on the market that is backed by a law firm, and a law firm that only does self-defense work. And they're always expanding upon their benefits to give you as much as possible as a member. So again, you can check them out using the links down below. And right now, if you use my code ARMSCHOLAR, you can save some money on your initial sign-up fee. Now, to understand why this case sent shockwaves through the legal community, we have to look at the bizarre facts that actually brought this case all the way up to the United States Supreme Court. So the petitioner here is a Florida resident, Mr. Keon, who was charged by state prosecutors with multiple felony counts of practicing chiropractic medicine with a suspended license. Now, under normal circumstances in a federal court, if you face serious prison time, you are guaranteed a traditional and robust 12-person jury to stand between you and the power of the state. But Florida, along with 5 other states, including Arizona, Connecticut, Indiana, Massachusetts, and Utah, have exceptions to that rule. For non-capital offenses, they shrink your constitutional shield down to just 6-person juries. Mr. Keon was forced into a trial before a shrunken 6-person panel, convicted and sentenced to over a year in prison, followed by 5 years of probation. Now, Mr. Keon fought back against that, demanding that his 6th Amendment rights to a full 12-person jury were actually violated. The State of Appeals that reviewed this case and his arguments outright rejected those types of claims, pointing to a 1970 Supreme Court precedent called Williams versus Florida. Now, in that older Supreme Court ruling, the past Supreme Court used a cost-benefit analysis, claiming a shrunken 6-person jury could be equally effective as a traditional one. But Keon's legal team just brought this issue straight to the Supreme Court, arguing that the era of watering down the Bill of Rights is officially over. He argues that the Supreme Court's new precedent has actually changed this, and that has been developed and changed after that prior ruling. Now, the question is, why now did the Supreme Court grant review to this case? Well, that's because Keon's petition completely corners the Supreme Court using their own modern logic and some new precedent. In his petition for review, Keon pointed directly to a massive landmark victory from a 2020 case called Ramos versus Louisiana. In that case, the Supreme Court completely struck down non-unanimous jury verdicts, ruling that the 6th Amendment must be interpreted exactly as it was understood when the Bill of Rights was adopted in 1791. The court in Ramos explicitly rejected the exact kind of cost-benefit analysis that was used in that prior 1970s case Williams, stating that it is not the job of judges to decide which historic features of a jury trial are important enough to keep and which ones they can actually discard. Keon's argument goes back to the originalist concepts and focuses on the intent of the founders. He argues that at the founding of this country, the word jury meant one thing and one thing only: 12 ordinary citizens that served on that panel. He argues that when the people enshrined that right, they did not attach a rider or an exception allowing future states and bureaucrats to downsize that right to simply save time or money. Now, in this case, Mr. Keon has filed his opening brief and submitted his main arguments to the Supreme Court. The opening brief makes two central arguments. First, Keon argues that the Sixth Amendment's guarantee of a jury trial must be interpreted according to its original public meaning, and that the historical record overwhelmingly shows a criminal jury meant 12 people. He relies on English common law, colonial practices, founding era treatises, and early state court decisions and rulings in the Supreme Court's own older cases as well. He then argues that Ramos versus Louisiana changed the governing methodology by rejecting that kind of functional cost-benefit reasoning that was later used in Williams versus Florida. In Keon's view, Ramos effectively undercut Williams so completely that the court can treat that Williams prior case as having no continuing force and essentially is now overridden and done away with. Now, second, Keon argues that even if Williams is still technically good law, the court should formally overrule it. He says that Williams was egregiously wrong because it ignored the historical meaning of the jury trial right and because its practical assumptions about six-person juries have not actually held up after that ruling. His brief cites research suggesting that these smaller juries are less representative, that they deliberate less effectively, and are less likely to include minority viewpoints and may increase, the risk of erroneous convictions and just fast rulings as well. He also argues that any state reliance on the six-person system is limited and cannot outweigh the constitutional right that is currently at stake with this case. Now, this is where this case applies to all Americans, especially you if you're a gun owner. So think about this. If the government is allowed to prosecute complex, high-stakes Second Amendment cases or technical compliance violations before and in front of a shrunken six-person jury, it becomes drastically easier to secure a conviction. And that is some of the research that Keon points to in this opening brief. It takes far less effort for the state to manipulate or to pressure six people. Oftentimes they don't weigh, the evidence as effectively, they don't take as long, and they don't deliberate, as effectively according to some of the research. And so that is a lot of the concern that's being raised also in this case. Also, this impacts your fundamental rights as an American by watering down the protections that the founders actually intended when they enshrined the Sixth Amendment. But now all of this is coming to a head before the end of this year. The opening brief is now filed, and the amicus briefs and response briefs will likely be submitted now very soon. And it appears that all the parties are currently targeting oral arguments to take place before the end of this year. They said that they want it to take place in December. So make no mistake, by granting review to this case, the Supreme Court's conservative majority has signaled a massive potential change on a critical constitutional right. They are poised to declare that states cannot alter, shrink, or dilute the literal text of the Bill of Rights under the guise of administrative convenience, time savings, or cost savings. The constitutional shield of a 12-person jury is on the verge of total nationwide restoration, but until the final decision actually drops next term, every serious felony trial across those six major states that are still using the shrunken jury remains in question and is really a legal minefield for them as well. So that is the critical case that the Supreme Court just granted review in, and now opening briefs have been submitted to them. So I will be tracking this as it moves towards the oral arguments, but let me know your thoughts down below in the comment section. Do you agree with these states using a shrunken jury, or do you support, the constitutional 12-person jury? Do you think that that is actually what the founders intended? Let me know down below in the comment section your thoughts. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.